Hi, this is Alan Gassman, and it is a beautiful, dry Wednesday, June 8th here in Clearwater, Florida, and in New Mexico, where my friend Lester Perling is. And we are here today to give you Lester's Florida medical law update. And before we get started, let me mention that set your calendar, please, for June 22nd, Wednesday the 22nd, for Part 2, which will be a federal medical law update. And we welcome you here. Please, during the presentation, feel free to send questions to me at gassmanpa.com, and I'll run them by Lester so he can answer them. Also, these are free webinars given by Bloomberg B&A that I am hosting. Please note that the next one, June 15th, is Gideon Rothschild on basic and intermediary considerations for asset protection trusts formed offshore and in asset protection trust states. And July 14, John Porter on basic but effective estate tax planning techniques and how the IRS may look at them. But all of these on the list are free, and we hope you join us. They're certainly worth the cost. Some of our proprietary webinars also free. Jay Atkinson on the Uniform Voidable Transfers Act. Sri Kumar Rao, very popular speaker, is returning to talk about ethical frameworks. Get a free half ethical hour, Wednesday, June 29th. Very enjoyable. And then finally, last but not least, Lester on the fraud and abuse laws as applied to drug treatment centers, Wednesday, July 13th. So Lester, I'm going to turn this over to you, and if I might ask, could you please give us a preview of what has changed on the federal scene that you'll be talking about in our next webinar?
Sure, Alan. Good afternoon, everybody. The next webinar is going to cover primarily two things, and I may add a couple of others after I think about it, but the purpose and the primary issues that will be covered will be revisions to the Stark law. There have been some fairly recent, not law, I should have said regulations, some fairly recent amendments to both existing regulations and exceptions, along with a couple of new exceptions. And one of the new exceptions relates to shared office space and equipment, so for which there never was a specific exception, although people would use others. And then the other thing we'll cover predominantly will be the relatively new regulation published implementing the 60-day notice and refund requirement for Medicare and Medicaid. It's been in the law for 2 or 3 years, but there were never implementing regulations published for most providers, including physicians, until a couple of months ago. So we're going to talk about some of the highlights with regard to that regulation, which is really a pretty important issue for physicians and other providers to know about. So.
Very good. And have you published articles, or are there any materials in particular that you think the viewers may want to read on these issues?
I mean, there have been a lot. I haven't published one on either. What I've done has been for clients, but there have been a lot of articles published on both the Stark regulation revisions and the 60-day rule regulations. So, listeners can Google it and certainly read up more about it. And some of those publications are better than others. So if I'll try to remember prior to the 22nd to look at a couple and see what I might recommend as being, both accurate and relatively complete.
Okay, super. Do you want to run the slides, Lester, or do you want me?
How do I do it? I can do it if you remind me how to.
Arrow right or left?
Okay, gotcha. Not working.
Okay, I'll run them. Just go ahead and let me know when to change. Or
okay.
Actually, Stephanie is here, and she's going to push a button to give you some control.
I love control.
It's only an illusion. Why don't you go ahead and start talking?
Sure. All right, so One of the things the legislature did, and we'll cover a couple of these bills in the past session, is address some issues with regard to physician assistants and nurse practitioners that had a tendency to limit the scope of what they might be able to do under Florida law, or at least were unclear under Florida law. You know, the mid-level practitioners are becoming more and more significant, not only in Florida but around the country, primarily as a result of the Affordable Care Act and more folks having insurance coverage and therefore seeking care, but also due to shortages in some particular specialties and in particular locations of physicians, as fewer people go into training and the number of residencies are cut, which was unfortunate timing given the passage of ACA with increased insurance coverage. And while some of that is being addressed, there's obviously a time lag that in that process. So mid-levels are going to become much more important for those reasons and others, just in terms of the cost of delivery. So this is one of the bills that was intended to address the use of mid-levels, specifically with regard to physician assistants. And it really just sort of clarifies vague language in the existing authorizing statute to make it clear that PAs can essentially perform whatever is delegated by the physician, so long as it's consistent with his or her education and training. And specifically, PAs were delegated or can be delegated prescribing authority both in paper and electronic form. Before there was some question about being able to prescribe in electronic form, and for me, I know now when I go to my doctor, I never get a written prescription, or virtually never anymore. The prescription is sent via e-prescribing to the pharmacy, so that's clearly becoming a more important part of the practice to make practices more efficient and frankly more consumer friendly. And you'll note that there's still a provision that says, despite this sort of general authorization, if a PA is specifically prohibited from doing something, of course, they can't do it, which would only make sense. My arrows still aren't working, Alan, so if you go to the next.
There you go.
Next slide.
Gotcha.
There it is. Okay. All right, so this bill covers quite a lot of issues that I want to talk about, and a lot of them were intended to address identified problems with patients going to a hospital that is contracted with their particular health plan. However, they get to the hospital, they get the service, and then they discover that the radiologist or the anesthesiologist or the pathologist or some other group, it could be the intensivists that are contracted with the hospital, are not contracted with the health plan, and so they're out of network. And so the patient thought they were going to see all in-network providers, and so that their in-network benefits would cover, based on whatever the coverage policy was, not seeing an out-of-network provider for which they may have no benefit, or if they do, it's going to be a significantly increased out-of-pocket cost. Generally speaking, when folks were admitted to the hospital, they never even knew that, so they wouldn't have known that until they received the bills from these professionals who were in fact out of network. So that's what this bill primarily addresses. So basically now it prohibits an out-of-network provider like the radiologist or the pathologist from billing members of a preferred provider organization or exclusive provider organization for both covered emergency and non-emergency services as an out-of-network provider. So it has to, the payer has to reimburse services as if they were in-network, even though those hospital-based providers were out-of-network. So that's a fairly big change. And certainly a benefit to consumers, and addresses what had become a much more common problem where more and more physician groups were letting themselves be out of network in order to get an overall increased level of reimbursement. So the There's also a similar provision in the last bullet point with regard to emergency services, so that the emergency physicians would be similarly covered as in-network, even if they were not contracted with the particular plan. And in addition, it prohibits insurers from denying coverage based on lack of prior authorization for emergency services, and that, again, they must be covered whether or not the provider is participating or non-participating. So that would be true for a hospital too. So if a patient goes for emergency services to a non-participating hospital, assuming they were really legitimate emergency service, it would have to be covered by the plan in some form or the other. Again, legislature here trying to protect consumers from surprises when they receive services.
That's pretty profound. That's going to really hurt a lot of specialty groups.
Well, yeah, I mean, I'm sorry, go ahead, Alan.
What is the level of reimbursement? Because a lot of these plans would pay certain of their doctors on panel 80% of Medicare, some of them 105% of Medicare. Does the statute decide what the level of compensation is to be?
I don't think so. I don't recall seeing that in the statute. It does require, and I don't have the details in front of me, I'm sorry, but it does require a process to be in place. Most of them, it's likely to be the predominant rate. I don't think there's a fixed set rate that they have to pay. And you're right, because of course the network providers are paid at different levels. A lot of plans for out-of-network services now use what's called the predominant rate, which is a mystical rate that only the plan knows in terms of the predominant rate it pays for an in-network provider. So more and more plans, and I've been dealing with this lately with United, and it will only pay an out-of-network provider the predominant rate it pays in-network providers. So what they put that in their their contract of insurance with the employer or with the individual. And so the days of getting paid, based on UCR for out-of-network are kind of coming, or will be coming to an end at some point for the most part, in probably the not too distant future, as plans try to figure out how to avoid these higher payments to out-of-network. And they were really hoisted on their own petard because of the way their plans were written. So they're rewriting those plans. So I'm assuming that it's going to be something like this predominant in-network rate. And that probably is addressed in the bill. I just don't recall exactly what it says.
Gotcha. Okay.
So like I said, the sort of the out-of-network boondoggle for providers is probably going to be coming to some degree to a close in any event. All right, the next slide. So what this provision does is amend, which I'm trying to pull up. Florida statutes has a provision in it in 408.07057, which is in the slides, that addresses it provides for a dispute resolution process between providers and insurers. And it's for some reason very little known and very little used. And in fact, in 2015, it was actually only used once. There were some more disputes filed, but for one reason or another, they didn't end up going through the process. And so there's actually the ACA contracts with an independent organization, Maximus, to be this dispute resolution provider or organization in these contexts. And there is a fee for its use, which may be one reason that it's not used more. I think the fee for the one matter that actually was completed in 2015 was like $1,500. And there are some specific requirements to be eligible to use this dispute resolution process, which I won't go into. But if you Google statewide provider and health plan claim dispute resolution program, you'll get the 2016 annual report, which describes the current program and talks about what occurred in 2015. But more importantly, it tells you when you're eligible, when you're ineligible. Doesn't have any detailed fee information, but there is a fee charge. And actually, if a case goes through that process, the resolution becomes a final order of the Agency for Healthcare Administration that's enforceable in court, like any other final order. But what this bill does, it amends this statute that I mentioned in a couple of different ways. One, it provides for, much like there exists in offers of judgment in civil court, it provides for sort of an offer of judgment process. And that's described. I won't go into the details, but that's described in the slides. There's a few bullet points that talk about these offers of judgment and when they're what their limits are, and if they're not accepted under certain circumstances, then there would be a final order amount, and there'd be attorney's fees implications. So what it's trying to do is to, I think, even make this process perhaps somewhat more user-friendly and maybe get more people to utilize the process. Then the other thing that this bill does in terms of amending the existing statute is add some more some procedural requirements, including that the resolution organization recommendation that the agency would adopt makes finding of facts in its decision, and that the resolution organization consider all documentation submitted by the parties, that parties can request an evidentiary hearing, which I guess doesn't exist now, and that the organization can't communicate ex parte with either the health plan or the provider. So like I said, a lot of people don't know that this process even exists. I think it probably has somewhat limited usefulness, but nonetheless, it's something that is certainly important to know about. I think most attorneys anyway will generally negotiate directly with the plan in an effort to resolve their disputes, and if that doesn't work, then perhaps litigate. And this statute doesn't prohibit litigation, so you're not required to go through this process in order to gain access to court. And it is an administrative process. It's subject to a final order and review by the Secretary of ACA, which also makes it somewhat iffy, because you can get perhaps a good outcome from the resolution organization, which may not be adopted by the agency secretary. So the process lacks some degree of finality, but it may be a consideration in the right cases. Next slide, Alan. And for some reason I've lost the slides on my screen, so I can't see what's up there, but I'm assuming we're on this same slide. So another thing that and this is really repetitive with the earlier slide, but points it out a little more clearly, is that insurers are now required to provide coverage for emergency services, I said, without prior authorization, and whether there is a participating provider. And if it's a true emergency service, the patient cost sharing must be the same whether it's a participating or non-participating provider. And willful non-compliance by a provider with the billing provisions are grounds for discipline by the Department of Health. And the bill even goes so far as to make it an unfair and deceptive trade practice for providers to be repetitive non-compliers. And that's a pretty tough penalty on providers, because that statute provides for attorney's fees and other penalties. So it becomes much more than a fine that one has to pay to the Department of Health. It really becomes a liability to the patient, because the patient would have standing to sue under the Deceptive Trade Practices Act. And perhaps more importantly, it leaves plaintiff's attorneys the opportunity to file a class action, which raises the ante for providers significantly. So obviously the legislature was pretty serious about this particular provision, because that's really, in my experience, that's very unusual, and I can't think of another statute that governs healthcare providers, or maybe one or two in some other context, that includes this as a specifically identified penalty. So,
Lester, what would a provider do? I see that the insurer has to provide the coverage for emergency services, but what would a provider do?
The provider would charge more than the in-network amount. So let's say the provider is out of network. Let's say it's the emergency physician group. And so they're out of network. The patient receives covered emergency services. And under their plan, if they were in network, let's assume their out-of-pocket would be $20. All right.
Right.
But the provider tries to bill them as out-of-network and bills them $520. So it would basically be balanced billing. That would be a willful noncompliance.
I see. Okay.
So the out-of-network provider is going to have to be aware of, and make sure that they check with the plan what the in-network cost share is for the patient, so that they're not, or wait till they actually get paid and see what's on the remittance advice, so that they're not out of compliance with this law. And probably the biggest risk will be the plaintiff's attorneys who like to do class action suits under the statute, looking
Right.
for cases, perhaps more so than individuals.
Very good.
All right, next slide. So again, in the statute, obviously this is a very consumer-friendly healthcare statute. Hospitals are now required to put information on their website with regard to how to contact practitioners and practice groups that contract with the hospital. So, a lot of times to patients, those folks are kind of mysteries. And, they don't know who the pathologist who looks at their specimens. They probably don't know the radiologist. They may not know who the anesthesiologist is. So this requires that the hospital disclose the identity and contact information of those providers that contract with the hospital. And also there's some notice requirements that are shown on the slides there. And you'll note that these are conditions of licensure now for hospitals, surgery centers, and urgent care centers, which is interesting because urgent care centers are not that regulated. They're not specifically licensed, but the legislature is, much like several years ago, there was a bill passed to require pricing information be posted for urgent care centers. And now this bill also recognizes urgent care centers, even though there's no specific licensure category for them. And then again, there's some obligations for insurers who have to post participating providers and contact information. I think most of them already do this, but nonetheless now it's required by Florida law. Next slide, Alan. This is a pretty limited bill which permits now the medical use of cannabis for terminally ill patients under certain circumstances. The definition of terminally ill is people who can reasonably be anticipated are going to die within 1 year if the condition runs its normal course. So there's some other specifics in these slides, and which we don't need to go into. One of them, in order to avoid people sort of looking for cannabis, is the physician has to have treated the patient for at least 3 months. So it can't be someone who's doctor shopping to look for cannabis. And then Alan, the next slide, provides some additional information. All right, next slide. This slide people have been advocating this for a while. The legislature finally did it, and this bill is really intended to reduce the significant nurse shortage in Florida. And what it does is it authorizes Florida to enter into the revised Nurse Licensure Compact, which is a multi-state agreement that for any participating state, a nurse who's licensed in one state can practice in another state that participates without having to be separately licensed in that state. So it basically allows nurses to more easily and more quickly move from one state to another. And it will allow contract nurses, temporary nurses particularly, they can come in, cover a hospital department if needed for 3 months and not have to get a license, where otherwise that wasn't possible, because if they didn't have a Florida license, they couldn't get one in any amount of time that would be of any use to anybody. You'll note that the effective date of this is off in the distance, December 31, 2018, or earlier if the nurse licensure compact is accepted by a minimum of 26 states. And right now, it isn't 26 states. It's a fair number below that. I don't recall what it is. But again, this is trying to ease a medical professionals shortage. Next slide. This one has been battled in the legislature for a while now. The legislature finally passed it, and it allows PAs and nurse practitioners to prescribe controlled substances. So their usefulness in certain settings was limited because they couldn't prescribe controlled substances, for example, in a hospital if they were making rounds. There are some limitations that are noted on the slides. An interesting one is that they cannot prescribe in a pain management clinic. So any physician's office that has to be registered as a pain management clinic, in that setting they can't prescribe, but they can in any other setting. And then they're required to complete some education. Next slide. This is another also part of healthcare access, which requires use of standardized pre-authorization forms that the Financial Services Commission has to adopt in order to get a medical procedure or a prescription drug benefit. So different payers now can't require different forms and different information. It will have to be consistent. Next slide. This bill just expands slightly a physical therapist's ability to treat a patient without an order from a physician. Currently, physical therapists can do that under certain circumstances for 21 days, and this bill expands it to 30 days, which I guess isn't a big difference, but I presume somebody lobbied for this, and so there must have been a reason. After 30 days, then a practitioner has to approve the treatment plan. Again, another effort by the legislature to provide greater access to health care for folks. Next slide, Alan. This slide again addresses prescribing by PAs and nurse practitioners, and it allows them to order any medication to administer to a patient in either a hospital, nursing home, or ambulatory surgery centers, and allows, again, the prescription of controlled substance if that authority is expressly given by the physician within the hospital setting. Then a couple more. Next slide. This bill simply authorizes more study into the use of telehealth and creates an advisory council. Obviously, telehealth is becoming far more important in the delivery of health care across the country. And Florida right now it isn't very clear how it's regulated at all. So this bill is intended to authorize a study in order to provide some recommendations, which are sorely needed in order to make it more accessible in Florida. But that will be sometime in coming, and as you see, they don't have to report their findings until October 31, 2017. So that means any legislation would be another several months after that. This next one is a couple of minor points that are pretty self-explanatory. We'll skip that one. Next slide, Alan, which starts with updates various provisions. Again, these are some fairly minor points. The second bullet point, which actually is a little vague, it talks about eliminating a loophole pertaining to licensure and renewal certain felons. There's an existing statute that prohibits people who've been convicted of certain crimes from either getting a license or having their license renewed. But there was this interesting loophole or exception that was obviously the efforts of a lobbyist, probably on one person's behalf, that exempted practitioners who were trained prior to a certain time and who applied after a certain time. So it was obviously designed to either cover one particular practitioner or a very small group. But anyway, that loophole, that exemption has been eliminated. So now it covers everybody. So it was a little bit vague, so I wanted to clarify that. Next slide. So this one is about pricing. As our audience may know, Governor Scott is very big about transparency on healthcare pricing, and he's certainly been after the hospitals with regard to that issue. And so this now requires that the agency contract with a vendor who's going to create a database, a searchable database, that's going to have hospital and ASC pricing information that's sort of bundled by service. So if you're going into an ASC for, I guess, like a hernia repair, you can look at this database, or we'll be able to look at this database and see about how much that's going to cost. And obviously these would be on a cash basis, assuming that there was not insurance coverage. This bill also requires insurers and HMOs to provide a method for their policyholders to estimate cost of services. Again, some already have that. A lot of the larger plans do already have a mechanism to do that on their websites, but this now requires them to do so. So I think that's it. So I guess the themes here with regard to bills passed by the legislature and approved by the governor this year, as they relate at least to practitioners, they primarily fall into two categories, and that's access, or maybe three categories: access and transparency in terms of pricing. So the legislature was quite busy in this past session in that regard, and I expect we'll see that continuing over the next couple of years.
Hey, Lester, that was excellent. Thank you very much. Thanks everyone for attending. And don't forget to sign up for the 12:30 or 5 p.m. Wednesday, June 22nd federal medical law update, which I am sure will be excellent. Lester, good luck with your eye infection.
Thank you, Alan.
I hope New Mexico law is as good as Florida law for handling that.
There aren't as many laws in New Mexico. It's a Wild West, remember. So.
All right. Well, bring your gun and have a great afternoon.
All right. Talk to you
Take
later.
care.